Yeah.
Very well. And
Is
my
this
lord's
like it?
constitutional bench judgment may
Notice and tag.
also clarify that. Grateful, my lords.
Can I make a request?
Yes.
I'll withdraw it
All.
with liberty to move the High Court of an expeditious hearing.
Right. Mr.
Better
Murthy,
not-
Leonard Sinha states that
Looks better
the
not
petitioner
go
would
back to
wish
the High
to
Court
withdraw,
rather than-
wish to withdraw the special petition, since the petitioner intends to move the High Court for expeditious
Very good,
disposal.
very
The
good,
the special petition is dismissed as.
very good.
Well, it's item 20, sorry. Well, it's I.
Steve,
Wait, please, my lord, because last time I'd handed over a deed of settlement pursuant to which they were supposed to pay us $75,000. My learned friend sought time to take instructions in this, my lord.
Lordship, we tried to connect with the client, but we could unable to connect. And we know.
So then we'll have to appoint an arbitrator.
Yes.
We'll have to appoint an arbitrator then.
It's a tribunal of three, but if only sole arbitrator can be appointed.
We'll appoint a sole arbitrator. How much is the claim, you say?
Plus, the total claim was $234,307.
234,000.
Out of which 50,000 they have paid, so I must acknowledge that.
They have paid 50,000.
Yes, pursuant to this deed of settlement.
All right. Ms. Vanshija Shukla was appearing in this in a previous matter. We'll appoint Ms. Vanshija Shukla as the sole arbitrator.
Yes. Item 23. Obliged.
Just tell Vanshija we have appointed as our sole arbitrator.
Mr. Surendranath is appearing in this 23, my lord. Can
26.
23.
Same
Same.
tag.
But
Now we'll follow the same order.
read
Yeah.
petitioners, they are not intervener.
That's all right. We'll pass the same order. 26.
Not on this individual, but there are two difficulties now.
Ms. Vanshija, we have appointed you as a sole arbitrator in one previous matter. Please do it for the.
I'll just coordinate.
Yes.
Grateful, my lords.
Lord, we are not on the recovery from this particular person. I'm not on the state. But there are two difficulties in the order, my lord. What it has done, one,
Why make recoveries from an officer
No,
now?
Lord, I'm not-
The junior
no,
internal.
I'm
We'll
saying-
then keep the question of law open.
yes, my lord. But there is one point, if my lord may,
How much was the amount here?
my lord, I'm not on this, in
6
this
lakh.
flag. I'm not, my lord, I'm not. But what difficulty has happened, the why I'm saying, what has happened that he was appointed on this board and this qualification was essential. Now High Court says it is not. High Court says that if you are appointed in a below post and you are promoted to a higher post and you acquire that qualification which is necessary for that post, then also you have to pay that's the difficulty of the state. I'm not saying.
In regard the effective consequence of the impugned order of the High Court would be to restrain the state government from making recoveries of an amount approximately of rupees
6 lakh.
6 lakh paid towards advance increments. So stop bearing in mind the facts and the quantum. They're not inclined to exercise the jurisdiction under Article 136 of the Constitution. However, we specifically clarify that question of law is kept open to be adjudicated in an appropriate case.
Deeply obliged. Deeply.
Especially petitioner. Item 28. You are appearing for the petitioner?
No, but for the respondent.
For the respondent. Who's appearing for the petitioner?
May I seek for a pass over, my lord,
All
because
right,
the
just
Mr. Call has.
pass it over. 29.
Your lordships may pass it over. Mr.
All-
Call is
all
leaving.
right. 30.
Lordship, I seek for a short passover. We are led by the learned SG in this matter.
29 Lordships can't hear, I know, but otherwise we are ready and we are keen to go on. But
Let's see, let them, we'll keep it on the reopening, yes.
that's the only issue.
On item 30,
Lordship,
29, my lords, is keeping on the reopening.
no, we've just passed it over. Let him,
Pass over.
whoever is coming, come.
Yes.
the Lordship, in item 30, we seek for a short passover. We are led by the SG and he is
All right.
11.
31.
My lordship's interim order has been complied with.
Your
We
lordship.
have been allowed to register and consequently will be taking the exam.
Your Lordship, we've,
Further directions are required now. We just stand it over.
please, Your Lordship, because we have the rules
We
ready.
had, we had allowed these students who are in the final year of the law to appear for the All India Bar examination.
Already covered, Your Lordship, this AIBE exam.
That's
For the next exam, the rules are ready. We just need to put them to the stakeholders. Your Lordships have it after 4 weeks. We should be able to submit them.
Right. The interim order dated. That was passed in this Nilay Rai case.
Yes, Your Lordship.
20 September 2024 has been complied with, and the petitioners and similarly placed candidates have been permitted to similarly placed candidates who are pursuing their final year of the LLB degree course, right?
Yes, madam.
Have been permitted to be registered for the All India Bar examination scheduled to be held in the month of
25th November, Your Lordship.
25 November 2024. Full stop. Learned Counsel appearing on behalf of the Bar Council of India states that the rules in the meantime have been prepared and are in the process of stakeholder consultation.
Please, Your Lordship.
Should we dispose it off now?
Lordship may have it after 4 weeks. We'll place it before Your Lordships because then otherwise the interim order will.
List on kar do after 4 weeks.
I'm highly obliged, Your Lordship.
Obliged.
You know?
Your Lordship may give a short passover. Senior Counsel is coming the way.
33.
I'm requesting for short passover, so 33.
Who's appearing in 33?
Mr. Gonzalez is appearing. Mr. Gonzalez is appearing. I'm sorry.
Okay.
Sir has filed a.
All right, let's make the Passovers then. 39.
30 and 39 are to be heard together, so we'll seek a short passover in both.
This one. We'll keep it on the reopening.
29 Passover.
28 Monday ko rag do. 29.
Your Lordships may recall this is the international.
I'm here.
Yes.
Oh, 29, I'm sorry.
Your Lordships may recall this is the International Arbitration Award, which has been upheld by the Section 34,
Yes.
set aside by the 37.
You can
Your
start the matter then.
Your Lordships may take. Mr. Kaul is leading me in the matter, Your Lordships.
For the petitioners?
Dr. Singhvi was just.
We are for the petitioners.
Mr. Kaul is for the petitioners and Dr. Singhvi is for the respondents. Oh, yes. Okay. 30.
On a non-miscellaneous day, Your Lordships.
Keep it on Monday and we start for 10 minutes. You can keep it on the following Tuesday then. 30.
30 and 39, Milord, I think the learned solicitor.
But I appeal for respond number 1 is right.
This is, Milord, that award against
know.
IRB. We had made an offer for the court.
Yes.
The learned solicitor is not available.
32. Anybody here?
Milord, 30, your lordships have kept back.
Yeah, kept
Yes.
back. 32.
In item 32, my friend had to file a response, Milord.
You're for the National Medical Commission.
Yes, Milord.
This is it's a very interesting case of a candidate who is physically challenged, wants to appear for apply for admission to the MBBS degree course. Now, we got the evaluation done by Dr. Satyendra Singh, who says that with assisted devices, that candidate is capable of, doing the MBBS. We thought we'll seek your assistance as the medical commission.
Milord, I have taken instructions in the matter. The child is very bright, Milord. The number he scored in the NEET is 610 out of 720.
610.
610.
So if he was not physically challenged, you would get admission where? You
Very good college, very good college in the country, Milord.
Now, what has happened for this year?
This year, Milord, it is going on. He has time till tomorrow, Milord, because counseling, the process is there, Milord. The only one concern we have one concern.
That we have perused the report. Though the petitioner suffers from a physical disability, we have duly considered the report which has been submitted by Dr. Satyendra Singh in pursuance of the order dated.
In pursuance of order dated 1810.
18 October
My lord, let me
2020.
suggest, my lord, it will I'm not going against his admission. The only thing I want to say is, my lord, as per the regulation, my lord, the medical board has to be constituted with the specialist of that disability. Like for locomotor disability, the person has to be from orthopedic and neurology has to be there, my lord. We have two AIMS report, my lord. Dr. Satendra Singh is only a physiologist, my lord. I'm not going against the admission, my lord. My concern is the report. So what my suggestion, I'm giving a suggestion, my lord. Let me give a suggestion.
Two reports.
Two tests. Now no further.
No, my lord. I'm not saying for any test.
Give him a chance. Give him a chance.
My lord,
Give him a
I'm
chance.
not.
What is your suggestion?
My suggestion is, my lord, in the facts of the matter, the petitioner may be given admission. But this judgment and this process should not be proceeded as a precedent. This is what I'm trying to say.
We'll say that.
Because he is not a competent person to give, but we are not against the admission of the student.
All right, Mr. Well, we have heard several appearances. The National Medical Commission has fairly stated before this court that, bearing in mind that the petitioner is a bright student having scored 610 marks out of a maximum of 728, he may be permitted to participate in the ongoing counseling process, subject to the clarification that the proposed direction of this court should not be treated as a precedent, concluding all issues of law which may arise in the future.
As well
any
as
other case.
As well as the latest report, my lords.
Report
is the problem is only the report. My lord.
Right, in any other case.
He scored 601.
601, my lord.
601. Full stop. We accordingly direct that the petitioner be permitted to participate in the ongoing counseling process for the NEET UG 2024. For NEET UG 2000, arising out of NEET UG 2024. Full stop. We clarify that this order is passed in the facts and circumstances of the case of the petitioner and the report which in the case of the petitioner, and shall not be construed in the future as the expression of any opinion by this court as a conclusive opinion by this court on any issues of law which may arise in an appropriate case.
No difficulty. Just to update, my lord, we are re-evaluating the entire regulation just to see how to.
Plus, there is a need for actually a complete change in the approach. If I may say so, with the highest amount of respect for everybody on the other side.
Anyway, we have granted relief to you.
Over.
Yes.
Matter is over.
Right.
I'm obliged.
Leave that. Thank you.
Grateful.
Grateful.
Yes. Lordship, I request. Lordship, I request if it may be taken up after lunch, Your Lordship, because Mr. Gonzalez
Bench will not be sitting after lunch, so we'll take it up on the
reopening day.
Why don't you give our submissions in?
Your Lordship, I have circulated.
You have circulated the submissions. all right.
Ideally speaking, Malaj, we would also want to bring something on record and affidavit.
When
But
bring it on record, it's a matter
irrespective
relating to issues of accessibility for the physically challenged in
But
public
Malaj, we've seen the
transport.
report. But Malaj, we've seen the report. The reports
We
conclude.
have referred it to the Nalsa Institute for
CDS.
for disability.
Yes. Malaj, but we've seen the report, but there are one or two observations which I want to make against. Malaj have seen it. In that, there's a conclusion that Rule 15 is contrary to the Act. That's one of the recommendations. According to us, Malaj have seen the Rule 15. It specifies various different standards and guidelines. Those standards and guidelines are, according to us, to be
Give
considered.
us some submission at least. Give us some written submission at
We'll
least.
do that.
When will you file it by? File it by this Monday?
Monday. Monday. I need a weekend.
Right.
Your Lordship, what I'm requesting is we have also make our suggestions independently of what Professor Amita Dhanda has made. She has submitted her report and her own suggestions. Petitioners have made their own suggestions. Kindly keep it on reopening day, Your Lordships. We'll
Liberty to them to file their submission. We'll keep it on Monday after the reopening. We'll consider it on Monday.
Yes.
Yes.
Yes, and my lords, that's what our submission is. to
Don't ask for time on Monday. It's a very important matter relating to access to public